Well, good afternoon, everybody. Thank you for the invitation and opportunity to present to your office here today. My name is Matt Troiani. I'm Vice President of Professional Development and Chief Counsel for NVAR. It's great to see friendly faces in these times. It's been rather interesting that there's been significantly less contact with our members for fairly obvious reasons, but it's always great to see smiling faces. On behalf of our board of directors, our CEO, Ryan Conrad, and the entire staff, we want to wish you all well. Hope that you're staying safe, staying sane. Before I get into the real kind of substance of what we're going to talk about here today, I'm just going to go over a few things as to what's going on with NVAR right now and how we're continuing to support you all. So first of all, I mean, the good news is, to a certain extent, while obviously you all are doing business in a different way, you're still able to do business. As of right now, deals are still getting closed. The banks are still open. Lenders are processing loans. Settlement agents are able to do very novel ways of closings and notarizations. Courts are accepting e-recordings right now. So you all, as long as we're able to observe social distancing guidelines and CDC best practices, you're able to do business. And so that's a good thing. And so as long as you all are out there doing that, then we are going to be here to support you. But just like you all, we're doing it in a different way. So we're doing virtual webinars all the time, including office visits like this and presentations. We are doing at least 2 or 3 webinars a week. You can find information about those. They're all free on nvar.com. If you happen to not be able to make the specific event, we are recording them. We're providing constant updates regarding COVID-19 resources, not just that we've prepared, but also from our state association, from the National Association of Realtors, CDC website, the governor's office, the various departments of health and human services, Virginia Employment Commission. There's a ton of stuff out there that we are updating on a daily basis. And while we are doing things differently, such as webinars, we are doing virtual CE and PL classes. So even though DPOR has said that you have to, they've kicked off the renewal period if you are going to renew during this time period till 30 days after the end of the state of emergency. We're still encouraging you not to wait till the last minute, especially if you're PL and you got 30 hours. That's going to be a tough thing to do in 30 days. So would encourage you all to keep up on those if you have the time. Check our calendar of events. We also are online for business. Our member services team and our education team, we are still answering questions and emails. I think we've already fielded several thousand calls and emails just in the last month. The legal hotline is still going. We've actually opened that up to non-NVAR members. That is now, if you are a DAR member or Greater Piedmont, Fredericksburg, Prince William, Blue Ridge, with the legal hotline is available to everybody in the region now. So I encourage you all to take advantage of that. And we're continuing to offer all of our products in our store. We've waived shipping to encourage everybody to place online orders rather than having to come in. We do have walk-in hours on Friday afternoon if you have like a lockbox or maintenance issue that you need addressed. You can you select like an appointment time period. You pull up in your car, you don't leave your vehicle. An NVAR staff person with a mask and gloves will come out, take your lockbox, swab it down, do whatever maintenance they need to do, give it back to you, and you're on your way. And we're also in the process of establishing some lockers outside of our Fairfax location so that if you have a pickup order, it's not going to be sent by mail. We actually put it in the locker. You can use your Sentry card or your Sentry Lock app in order to access the locker to get your goods that you purchased. So we're trying to figure out creative ways to observe best practices and continue to be there for you all, and we'll continue to do so. We've been collaborating at the local, state, and national levels to try to ensure that we're advocating on your behalves as well. So that's why we were able to keep the courthouses open and accepting e-recordings. We were able to work with the governor's office and the Department of Health to ensure that you all could continue to do business during this time and support your clients. At the National Association, the NAR has been very actively involved in the CARES Act, and hopefully it looks like they might be reaching a deal on the Hill today to expand the funding for the Payroll Protection Program and the Economic Injury Disaster Loan Program. And we are hearing that the Virginia Employment Commission is also now processing pandemic unemployment assistance, which is the $600 a month from the federal government, which for the first time ever is now available to independent contractors. So if you have suffered some kind of economic hardship, there are resources that are available to you all. If you don't have clients that are out there looking and you need resources, please check those out. But what I'm here to talk about today, which has been a little bit more long-standing, is some fair housing, property management, and leasing issues. It's interesting because we've actually gotten more and more questions about this in the 2.5 years that I've been with the association. It started out, you would just get these periodic questions, but it's become more and more so. It seems that more and more of our members are either becoming much more active in leasing and property management, or perhaps they're moonlighting and they just need to have some information. They've got a specific client who's looking to them for help. So we've been trying to address this with more information, more forms to support you all. But I'm going to go through a few best practices here today based off of some of the inquiries we get on the legal hotline, as well as the request that I received from your office. So number one, the most important thing to keep in mind when you're doing leasing and property management is arguably from a Fair Housing and a Fair Credit Reporting Act perspective, there's a significantly greater risk in the leasing space than there is in the purchase and sale. It's something that you should take very seriously because in order to make a similar amount of money, you have to do more leasing transactions, which of course, again, expands your potential risk and liability. So we don't encourage anybody to just dabble or moonlight. If you're going to do this, then figure out, use the resources at your brokerage, use the resources at your association, figure out how to do this properly. And if you can't, or you have a client who really is presenting a challenging situation, talk to your broker, find somebody else in your office that you that can help them or something like that. The most important thing is don't dabble. That you're providing the best services to your clients doing, because there is a lot of risk there. Some of the questions that we get over and over again from a fair housing perspective. The landlord wants to see the rental application. Well, I have a couple of responses to that. Number one, the rental application specifically authorizes the verifier to check all of the information. It does not authorize the landlord. And number two, if the landlord wants to review the rental application themselves, why did they hire you? That's why they hire a leasing agent to help them screen applicants, to essentially protect themselves from themselves a little bit. There is potential information that is included in a rental application that you need under federal law to have written permission to share with a party. The Social Security Act says that you cannot share a Social Security number without written permission. The Fair Credit Reporting Act says you have to get written permission in order to share a credit or background check with the landlord. So in this scenario, your job really is to take that application, go through all of your screening processes, and then just present the relevant information to the landlord so they can make an informed decision. You're looking at number of occupants, the proposed term of the lease, the proposed rental amount, a credit score range, whether or not they passed a background check, things like that. We're not getting into names because if you share a name, now there is the potential that somebody might be able to determine somebody's ethnicity or background based off of that name, which invites an opportunity for a potential fair housing issue. If you start getting into the family structure, how many kids? Are they married or not? That's a potential fair housing issue under familial status. Age, all kinds of information that from a risk management perspective, your job is to just distill it down to an information. Applicant A, this is their debt to income ratio, this is their income, here's their credit score range, here's how many occupants. Okay, compare that to applicants B, C, and D, and scrub out all of the other information. That is the most relevant and best way you can protect yourself from a fair housing perspective. A couple of other fair housing related issues that come up over and over again. Let's talk about guarantors. You have kids, maybe somebody starting out, they're a student in college, especially in our area. There's a lot of universities in the area, and they're looking for housing. As long as you apply it consistently, you can say that it could be required to have a guarantor, a parent co-sign the lease, because they're the ones who have a credit, have credit history. They're the ones who have a verifiable income and that kind of thing. So you can certainly do that, but do it consistently. If you are getting applications from people who don't have a credit history or don't have steady income other than maybe student loans, and you like to have a guarantor, well, then you're going to have to do that with everybody who is similarly situated, regardless of background, ethnicity, anything like that. Remember, discrimination is entirely about how you are treating people. You treat them consistently, and then that's not discrimination. Another thing to keep in mind when you are looking at working with students, for example, or young adults, maybe people fresh out of school, we get a lot of questions regarding occupancy of the home. How can we set the limits on who or how many can live there? So number one good fallback is always every county and city in our area from a zoning perspective has adopted a rule that says you cannot have more than 4 unrelated persons in a property. So if you are getting an application from 5 or 6 people who are not related to one another by blood or marriage, then you can reject on that basis. That is neutral as long as you're doing it consistently and you're complying with the law. But if it's less than that, if it's 4 or less, we hear a lot of questions. People get into conversations about, oh, well, no more than 2 incomes to qualify. Well, now you're doing something that's potentially inconsistent based off of familial status. And so in that scenario, you would just evaluate all of the applicants together rather than just setting a benchmark of, no, we're not even going to consider more than 2. I mean, chances are if you evaluate all of them together and it's possible that, they don't have the credit history or they don't have the income, then you can reject them on that basis. That's an objective basis upon which to say, no, we're not going to consider it. But if it's 4 or fewer unrelated persons, you've got to treat them the same as you would anybody else, regardless of whether or not they're related. Diplomats. We get a question in our area a lot about diplomats. You got people who are coming in, they're working at non-governmental organizations, they're working for embassies in the area, and they need housing. Technically speaking, being a diplomat is not a protected class. You all may see that on the NVAR VRLTA lease, it actually has a checkbox. It's a notice regarding diplomatic status. And the reason for that is if somebody has a diplomatic immunity, that means that you cannot pursue them for damages if they breach the lease. They have immunity from damages in court. So that's a potential objective basis upon which a landlord might not want to accept a rental application, because you can evict them, but if they tear up the property or they fail to pay rent for several months, then the landlord's going to be out a significant amount of money. So that's something that you definitely need to take into account. I did see that a question will pop up. I'll get back to that one in just a second as soon as I finish the diplomat discussion. But if you are going to say no diplomats, then you must do so consistently. Remember, it's an objective standard. You can't say, well, diplomats who come from countries on this continent or from this background are more trustworthy and I'm going to allow them, versus, oh, people from this other continent or this other background, I don't trust them, so I'm not going to allow those diplomats. Say no diplomats, you have to be consistent and apply it regardless of where they are coming from, because that could be potential discrimination on the basis of national origin. But something else that you can take a look at when you're working with diplomats is inquire as to whether or not they have any kind of guarantee. While the individual might have diplomatic immunity, if they're getting a rental subsidy or they're getting some kind of guarantee from some of the larger embassies, do this for their employees, as they realize that their employees have difficulty in getting housing sometimes because of the immunity. So the suggestion there would be is to inquire about whether or not the embassy would be willing to pay the money up front or to guarantee the loan. It's just a little bit more financially secure, but again, do that consistently. Okay, one of the questions we said, what do I mean by unrelated? What happens if 4 occupants go into college and want to rent a single home? In that scenario, you would treat them as you would anybody else. That's exactly the scenario that we are talking about here. You have 4 unrelated persons. So the question is, do you automatically have to allow them? Of course not. What you have to do is you have to take a look at their application and use objective standards upon which to either accept or reject the application. Not just the fact that they are unrelated, that's potential familial status discrimination. Take a look at their income. Take a look at their credit history. In many instances, you've got 4 people going to college. They have no real income except for student loans or maybe a part-time job, and they don't really have much of credit history. So in that scenario, you either reject it outright, or if you're willing to consider it, then in every instance, you would look for some kind of guarantor or cosigner. But you do it every time. You do it consistently. It's not discrimination. The numerical restriction, this person might have joined about midway through that discussion. Every zoning code in the area for counties and cities says that you actually are not allowed to have more than 4 unrelated persons in any property, regardless of the size. Even if you had 8 bedrooms in the house, you couldn't have 5 unrelated people in there. So that is specifically designed to address those situations. So hopefully that addressed those questions. I think that we covered the diplomats, unless anybody has any questions about that. I mean, in many instances, you know, yes, diplomatic immunity can be a concern, but there's always a credit risk. That's essentially what a landlord is doing when they allow somebody to occupy their property for a certain time period as a matter of contract in exchange for money. It's basically you're extending credit to somebody and the possibility that they could you know, cause damage to the house that you're allowing them to stay in. So a lot of it is a risk, but in many instances, except for maybe some very high level diplomats, most of the time they're pretty responsible tenants. They don't want to give their country a bad name, and they want to make sure that people are able to have housing when they come here. So if they say they are diplomats, you can say no without looking at anything else. You could, but I would do it consistently. You know, that is an objective basis. If they say not that they are diplomats, but they have diplomatic immunity. There are employees of embassies that do not have immunity. They're administrative level staff. They wouldn't necessarily have the same level of immunity as more senior people. But if they do have diplomatic immunity, that is an objective basis to say, no, we're going to reject the application. Now, in those instances, I mean, if you haven't even pulled a credit report and you haven't really reviewed the application extensively, you might want to consider not keeping that application fee, just as a matter of good faith and will, so that you're not really, you know, ticking anybody off. But I mean, that's a determination that you can consider. Certainly, if you've done your due diligence, you've pulled a background check, you've pulled a credit report, you've reviewed the financials and all of that, you've done that, and then there's a rejection, then sure, I mean, there's probably a basis to keep the application fee and any of the associated costs. But if you're just taking a look at it and it says, oh, diplomat, nope, then maybe you just might want to consider just saying, you know what, we're not going to collect that fee for the 45 seconds worth of work it took to look at that application. Okay. Anything else on diplomats before I move on? One of the other questions that we get a lot of, and I was asked to cover, and it's gone down a little bit in the last almost 2 years, but we get questions about assistance animals. Assistance animals is a broad category. Sometimes we hear some confusing terminology. People will talk about service animals versus emotional support animals. As a matter of law, they are treated basically the same. They both help with a disability-related need. And so we call that entire category, service animals on one hand and emotional support animals on another, we call them assistance animals. About 2 years ago, this was the most frequently asked question on the legal hotline. It wasn't even close. It was like a third of all tickets that were coming in. So in July 1 of 2018, we came out with some new forms in order to help landlord or leasing agents, tenant agents, property managers figure out how to process these requests because it's becoming much more common. And so the main difference between a service animal and an emotional support animal is a service animal is a specifically defined category. It's generally dogs or miniature horses, believe it or not, that they're trained to address a specific need. So for instance, somebody with vision impairment might have a seeing eye dog, or hearing impairment might have a dog that does their listening for them. Certain dogs are actually trained to be able to identify when somebody's going to have an epileptic seizure or a diabetic related shock. And so they actually are specifically trained and certified for these purposes. And it's a restricted category of the type of animal. Emotional support animals do not have the same certification. I hear all the time, oh, somebody presented this certificate from someplace in Kansas. I call it the Google School of making things up. I mean, that's great, but that certification is neither necessary nor sufficient. So what we did was we actually created a verification of disability form. We took all of the HUD guidelines and we said, okay, you can't ask for HIPAA protected confidential health information, but you can have somebody verify that the individual has a disability related need and the animal helps with that need. And so the verifier is typically somebody with whom the applicant or the tenant has a therapeutic relationship. It's a very broad category. We're talking social workers, psychologists, psychiatrists, primary care physicians. In certain instances, the verifier can even be the spouse. In many instances, you've got somebody who was a service member who was injured, and they have an emotional support animal because they have PTSD. And even their spouse, who, if they are kind of their day-to-day caregiver, can be the verifier in that scenario. So really what we fall back on is to say, look, you've got an applicant coming in, or you have a tenant subject to an existing lease, and they say that they have an emotional support animal. You can simply provide them with a verification of disability form. Say, here, please fill this out, and fill out the reasonable accommodation to rule or policy form. This is to specifically address the situations, because not every landlord has a no pets or no animals policy, or a restriction on the size, type, manner, breed, number of animals in the property. So what they do is they fill out the reasonable accommodation form because they're asking the landlord to give a variance, to give a waiver to their usual policy regarding animals in the property. And then along with that, if they don't have a doctor's note, you can have them fill out a verification of disability. The most important thing here is that if the disability is readily apparent, if you meet the person and it's clear they have a vision impairment, don't go like this in front of them or anything like that. You're going to have to take their word for it. And they don't have to fill out the verification of disability. It's been verified. But for emotional support animals, typically speaking, the disability is not going to be as obvious. You're talking about mental health issues or physiological tics, things that you wouldn't necessarily always be able to tell just by seeing them or interacting with them. Or in many instances, you never actually meet the applicant until they move into the property. So in those scenarios, the disability is not readily apparent. You can provide them the verification of disability form. I hear all the time that people are concerned about fraud with respect to this. And it's possible that there is some out there, but we have generally found, speaking to our members who do property management, that if you provide the verification of disability form and they turn it back in complete, chances are it's not a fraud. If they're trying to commit fraud and they're just trying to get an animal into the property and they don't want to pay the pet deposit or the fee or anything like that, you provide them the verification of disability form, you're never going to hear from them again. They're going to go move on to another property and see if they can do that. So generally speaking, we find that the people who know what they're doing, they're familiar with the process, they're going to have their paperwork in order and they're going to get it back to you in fairly short order. So just because the disability has been verified, though, does that mean that the landlord automatically has to allow it? Most of the time, yes. Now, you can certainly call the verifier's office to make sure that they are actually, an existing company, or somebody's willing to say, oh yes, we have a therapeutic relationship with so and so. You can do that, but that's really where the inquiry stops. You don't dig into the nature of the disability or anything like that. But once they've turned that in, there's the second part of the issue. It's whether or not the accommodation that they're asking for is reasonable. Okay, that's going to be a case by case basis. But most of the time, you're talking about your run of the mill dogs, cats, guinea pigs, hamsters, birds, things like that. The accommodation is going to be reasonable. Now, that doesn't mean you have to allow a llama or a horse into a 2-bedroom condo. But that's the issues that we tend to see, is more where it's kind of an extreme example, some kind of a non-domesticated animal, an agricultural or barnyard animal or something like that in a small property. So yes, we have heard about snakes, although honestly, certain snakes probably would qualify. Believe it or not, people actually develop affections. I personally hate snakes. It creeps me out, but I try to put those personal feelings aside when we're talking about that. But yes, I mean, a 14-foot Burmese emotional support python probably would not pass muster, but you're talking like, an average size snake in the, that they keep in a cage. It's no more than a few feet long, probably would be permitted unless it was otherwise banned by law. In those instances, though, it's not like the landlord is without recourse. If the assistance animal is approved, we have two forms. There's a denial notice and an approval notice. The denial notice has a few check boxes in which they're like pre-approved HUD guidelines. It's mostly that they didn't turn in enough paperwork or they weren't able to verify the disability-related need. Maybe you might be able to prove that if the landlord was self-managing the property, or might move back in the future, and they had they were deathly allergic to that type of animal, you might be able to say that it was a hardship or something like that. I'm not talking like hives or sniffles. I'm talking like EpiPen, trip to the hospital kind of thing. If you could document that, you might be able to reject it on that basis. Sometimes we hear about HOAs and condos have restrictions on animals. In that scenario, the burden on the landlord is to actually go to the HOA or condo board and say, hey, look, I know that we have this rule in place, but I've got an applicant who's got a verified disability and they're asking for an accommodation. Will you give me the accommodation so I can rent the property out to this tenant? And condo and HOA boards, believe it or not, are actually subject to fair housing as well. So hopefully they will grant it. Back when I was in private practice, I litigated a few of these, and you send the bill at the end where they're like, why did we have to pay you $75,000 to litigate this? And my response usually was, well, you didn't pay me $75 at the beginning to pick up the phone, and I would have told you not to do it to begin with. But if the condo board or the HOA board is going to be unreasonable, and they reject the landlord's request, then the landlord can always go back to the tenant or the applicant and say, hey, look, it's not me. I was willing to do it. It's a little bit of burden shifting, blame shifting. You're like, look, if you have a fair housing complaint, go file it against the condo board, not against me. Same with insurance companies, actually. I know that a lot of landlords have liability insurance that might exclude certain kinds of animals, but insurance companies are also subject to fair housing. So the landlord would have to go and try to get a waiver or a variance from the insurance company. So assuming that none of those categories apply, though, and the landlord accepts the assistance animal, then we have an assistance animal addendum. This is an addendum to the lease. Now, remember, you can't treat anybody differently on the basis of a disability. So you can't charge them a pet deposit or additional rent because they have the assistance animal. Okay, think of the animal like a wheelchair or a service ramp or something like that. Not a living creature or anything like that when you're trying to process this. So the assistance animal addendum does not have any option for charging the tenant additional money, but it still makes the tenant responsible for the behavior of the animal. If the animal, bites or becomes a nuisance, then that could be grounds for terminating the approval of the animal. If the animal causes property damage, like anything else, the tenant is going to be responsible for that. Now, remember, I said you can't collect additional security deposit though. So it's just something to be mindful of if the security deposit is not going to be sufficient to cover the damages. The only other thing that that comes to mind with the assistance animals, is of course use the forms, but the forms are designed there to protect the landlord and the tenant, but they're also designed to protect you all, so that there's a formal process by which you can review these applications. We're not making it up on the fly, because that's really where we get most of the issues from a fair housing perspective. Discrimination on the basis of a disability. Okay. So I'm going to pause here for a moment if anybody has any questions before I move on to a couple of other things that are going on that might be relevant to the current situation with COVID-19. Okay, so I don't know if you all saw this. Hopefully you did. We sent out an email last week. The board of directors approved 2 new property management forms for immediate release. At its meeting on Thursday, they have been put into all of the relevant forms vendors' libraries, so you should be able to find them. And also we have PDF fillable forms on our website as well if you need it on a more urgent basis. Now, I want to stress that these are property management forms. I'm sure that your brokerage is the same as others. If you're providing forms and services, you should be doing it pursuant to an actual agency relationship. We're not talking about you helped the landlord or a tenant 6 months ago. Now they're several months into the lease and they're having a hardship. Unless you are a property manager with an active agreement, you shouldn't be providing the forms. But if you are doing property management and you've got a tenant into the property and their tenant is suffering an economic hardship right now, we heard a sobering statistic the other day. This is nationwide. I don't think it's quite as bad in our region, but it still is a very real statistic. 1/3 of all tenants did not pay their April rent nationwide. So even if we're a little bit less than that, that is a huge number. So what we're trying to address is a situation where the tenant is furloughed or has lost their job as a result of the current circumstances, and they're not going to be able to pay all of their rent. What can they do in order to work something out with the landlord? Because the landlord is in a bind right now as well. Some landlords have federally backed mortgages on their properties, and therefore they might have a forbearance right now from the mortgage company, but they may not. Especially those are mostly multifamily properties. This doesn't really address the types of properties that most of our members manage, which are single family homes, townhouses, condo units, and things like that. So the landlord may not have a forbearance, and even if they do, they still have insurance and taxes. They have carrying costs on the property. They might be suffering their own economic hardship. But ultimately, right now, the courts are not available. While we have ensured that e-recordings can still happen, the landlord-tenant courts in the area are accepting filings, but they are not holding hearings. You're not going to get in front of a judge anytime soon. And even if you are, you get in line, because once they open up again, there's going to be a significant backlog in cases. So what is to be done at this point? The landlord can't evict the tenant. The tenant can't afford to pay the full rent. So we created 2 new forms to try to facilitate this conversation and some kind of mutual resolution, because our guidance to the parties is, look, y'all got to figure it out. You can't go to court. So you got to figure it out amongst yourselves. So we've got the first form is called the request due to economic hardship. The property manager sends out a notice to tenants saying, hey, if you have an economic hardship, please fill out this form, provide it back to us, and we'll evaluate it with the landlord. Now, it's a pretty straightforward form and asks the tenant to propose an amount of deferred rent. The rent is not being waived, it's being deferred. So it'll be a lower amount during the time period. And they're also going to request a certain amount of time, 30 days, 60 days, 90 days, 120 days, whatever they're going to request. It specifically gives the property manager and the landlord the ability to verify the information. Now, that might not be the easiest thing to do in the world right now. If a business has shuttered, there's no HR department that's fielding calls about verifying employment. But we wanted to build that in so that the parties could do the best that they could. It requires the tenant to provide all kinds of documentation, bank statements, proof of unemployment, whether or not they've applied for unemployment insurance or benefits from the state or the federal government, so that the landlord can properly evaluate just really how much the hardship is. It also specifically makes it abundantly clear to the tenant that it is the landlord's sole discretion to grant this, and that they do have the ability to, if there's any misrepresentation on the request, similar to our lease and the rental application, if you misstate something or misrepresent something, it's a potential breach of the lease. So you've got the request form. The landlord and the property manager take a look at it. They determine whether or not they can accept it. So then the second form is called the notice to request due to economic hardship. So the notice form has two separate options. First, there's a denial option. And then we have a couple of check boxes for the denial. The tenant didn't provide enough documentation, or they weren't able to verify the economic hardship, or it might cause an undue hardship to the landlord. So those are some grounds for denial. Or there's a second series, there's a second option, which is that they approve the request. And then, but the request is approved subject to certain very important provisions. Number one, they're going to define the amount of deferred rent, not the waived rent, deferred rent. They're going to define a time period during which the deferment is going to be active, 30 days, 60 days, 90 days, whatever they are going to do. It specifically invites the parties to check a box about how the deferred rent is going to be paid after the deferment period is over. So in equal monthly installments throughout the remainder of the lease, or equal monthly installments within X number of months. We left a blank for that. We specifically did not put in an option for paid immediately in full. And the reason for that is, number one, if we put it there, every landlord's going to choose it. And number two, our issue was, is that really realistic right now? Depending on how long this goes on, and how long the economic hardship lasts, you don't know if and when the tenant is going to be able to get their job back, if they can at all. We don't know what their financial situation is going to be at the end of the deferment period, whether they're going to be able to even make that payment. And so really the parties can still choose other, and they could put that in if they really wanted to, but we're encouraging some kind of payment plan because we just felt that the immediate payment option was unrealistic at this time. We specifically created this form as a notice, not an addendum. And the reason for that is we were concerned that there is going to be situations where the landlord and the tenant are not going to be able to come to an agreement. The landlord's always going to want more from the tenant. Tenant's always going to want to pay less. The landlord specifically is going to want to include what are called reservation of rights language. That, hey, even though I'm accepting less rent now, if you don't catch up in the future, I still reserve the ability to pursue you for damages or eviction once the courthouse is reopened. Most tenants, probably all other things being equal, would not agree to that kind of language in an addendum. So here we said, okay, let's just have the landlord do a notice. Hey, look, here's your request. This is what I'm willing to accept. And I'm going to reserve my rights. And the tenant is either going to pay or they're not. And so that's specifically why we did it as a notice instead of an addendum. We also created both of these forms to be very flexible. You can use them more than once. Because right now, one of the biggest things that we struggled with is we don't know how long all this is going to last right now. We don't know how long the economic hardship is going to last, or the deferment period needs to last, or when the tenant's going to be able to catch up on rent. I think we still need to do a reasonable approximation of it at the outset now, but what we wanted to do is to provide additional flexibility so that if a tenant applied and they didn't include enough information or the landlord rejected it, well, then they could submit a new request with new information, a new proposal, to see if the landlord accepts that. Or maybe the parties agree to 30 days or 60 days. And at the end of the 60 days, they said, oh, well, we need another 30 days, or we need another 60 days. Put in another request, do another notice. Or the tenant falls on significantly harder economic hardship during the time period. They say, well, actually, now we can only pay this. They can put in a new request and the landlord can decide whether or not to grant it. So similar to the COVID-19 addendum, similar to the inspection contingency removal addendum, we put a numbers box up in the upper right-hand corner so you can track which version of the request and the notice you've done. Because really what we're trying to do here is facilitate a discussion between the parties and realizing that there's no way to create a one-size-fits-all ironclad forecast for this. We just wanted to make the form flexible so you can use it over and over again as appropriate to the situation. I've got a question. Where can I find the form for the tenant to apply? If you don't mind, which forms platform do you all use? Which forms vendor? It should be, it is set up in, okay, you all use Dotloop. So Dotloop has confirmed that it is available in their forms library. It should be on their leasing or property management forms. But they're in there. Dotloop has confirmed that they're in there. You can look it up. The names are request due to economic hardship and notice regarding request due to economic hardship. But these were, we'll continue to evaluate these forms. I mean, these forms were put together pretty quickly in conjunction with several of our members volunteer leaders who do property management, as well as some attorneys in the leasing space. So we think that hopefully they'll be useful. The question was, can I repeat those names again? Yes. Request due to economic hardship. And notice to request due to economic hardship. And what if the tenants decide not to pay without a form? It's an excellent question. I mean, the issue here, of course, is that the problem is that you can't evict them. So the landlord is without serious remedy right now. We do not do self-help in the Commonwealth of Virginia. You can't just lock the doors and kick them out. You have to go through the courts, and the courts are not available right now. We hope that they will be in the future. But what you do in that scenario is certainly encourage the tenants to pay what they can. That's what this is really for. But if the tenants are not going to pay at all, the landlord would do what they would do with any other tenant. You give them a notice to, a notice to vacate or quit notice after 5 days of non-payment, and specifically include that reservations of rights language in case they do make a subsequent payment. Really, in this scenario, while the landlord doesn't have a direct remedy right now, they're preserving their rights so that at such time as the courts reopen, they can still go after the tenant for damages and eviction. But right now, really, everything is predicated on the notion of we can't go to courts to get a remedy. The parties need to figure something out amongst themselves. It's not going to be ideal. It's going to be a compromise, but hopefully it's one that they can both live with. And of course, if the landlord, right now, the status really depends on the landlord as well. If it's a landlord that has a federally backed mortgage, they're not allowed to evict their tenants. That was a provision in the CARES Act. So they can't file a negative credit report or anything. Now, that means that they should also be able to get a forbearance on their mortgage so that landlord is not in as hard of a place. But again, I don't think that is a significant factor in most of the leases in our footprint because those are mostly multifamily properties. Those are the big landlords, the big apartment complexes and condo complexes and things like that. It is not the landlord that's got 2 or 3 properties that they lease out typically. But other than that, I think that the biggest issue is, of course, you all need to continue to take care of yourselves. Be mindful. Some of the questions that we're getting regarding tenants, you're coming up at the end of the lease and it says that you can show the property during the end of the lease because you want to get a new tenant in there or you're going to sell the property. And the tenant's saying, no, not allowing anybody in. Technically speaking, the access does have to be reasonable. And the tenant should be allowing access, provided that you're saying that, look, we're going to make sure that only a certain number of people get in. We're going to wipe everything down. They're going to use booties and gloves and a face mask and everything like that. But again, if the tenant refuses and that refusal is unreasonable, you can't go complaining to a judge. So you've got to figure these things out. And I think in that scenario, it's really incumbent to talk to the landlord, property owner about, hey, do you really want to be going on the market right now? Either we need to figure out a way to make this tenant comfortable with doing the showings, or maybe we can figure out a way to keep the tenant in the property on a month-to-month basis for a few months until all of this passes. Because a bird in the hand is worth two in the bush kind of thing. So even if it may not be the most ideal scenario for a landlord, realistically speaking, if the tenant is going to create problems with them getting the property back on the market, is it really worth it, or can they simply kind of continue the status quo, keep the current tenant in place, and revisit it once the courts open or the market improves? If the landlord is really in kind of a do or die situation where they need to put in a new tenant or they need to sell the property, then certainly probably in that scenario, the most effective thing you could do is hire an attorney, spend them pay them a few $100s to write a legal demand letter and to scare the heck out of the tenant. But really, without access to the courts, there isn't any way to force the issue. But people do tend to pay attention when they get letters from somebody with Esquire on the end of their name. Okay. Any other? I'm trying to allow plenty of time for Q&A if you all have anything. Some of the other things that we're hearing, tenant just simply refuses to vacate at the end of the tenancy. I mean, you're kind of in the same boat in that scenario. Try to collect what you can from them. Reserve your rights until such time as the courts reopen, or see if they're willing to sign on to some kind of extension to the lease. Is probably your best option. Probably try to have a discussion about putting off non-urgent property maintenance and repairs issues. Of course, address urgent ones as best you can. And in most cases, I'm sure the tenants would like for the landlord or their manager to get somebody in there to fix them. But if they're, if it's non-urgent stuff and the tenant's not cooperating, you just might want to consider not forcing the issue, at least as of right now. Try to be understanding. I mean, people are, very reasonably scared right now that we don't have a good handle on exactly how long this virus stays in place, exactly how it's transmitted, what its course of, a significant number of people are asymptomatic who even have it. They don't even know it. We've heard, we leave this up to the brokerages. It's a risk management decision, but we have heard that several brokerages have produced like health waiver forms or like a health questionnaire or an acknowledgement or something like that. We're certainly aware of it, and if your brokerage does that and is encouraging you all to use it, then by all means. NVAR, as of right now, is not intending to create its own form for a variety of reasons. Where our position is consistent with the National Association of Realtors. It says, number one, we do have some protections in the brokerage agreements, at least protections for the brokerages. And number two, unless you've been living under a rock for the last 2 months, this is all that's been on the news. And so buyers, sellers, tenants, landlords are aware that there is a risk associated with providing access to property right now. And so the risk to the brokerage is fairly low in that scenario because essentially the parties are assuming the risk. They know that it's there and they're going to do showings or they're providing access anyway. So in that scenario, there isn't really a great deal of liability, we don't think, for the brokerages because they're doing this knowingly. Number three, we also don't want to create a false sense of security. The problem is that somebody is signing that form, they may not know if they are carrying it. If somebody else gets sick, how are they going to be able to trace it to that specific person? You might not be able to do so. So we're a little concerned about creating a form that basically says, hey, if you sign this, everything's going to be okay, and everybody can just go out, disregard social distancing guidelines and CDC best practices. And then the final reason too is that we're not sure if it's actionable. What if somebody misrepresents their condition on the form? What if they don't know but then they later find out that they are? Does that create some kind of contract or a cause of action? I just don't know exactly how that would work out, and So that's why we haven't created our own form for like showings and things like that. But again, we defer to the brokerages as a risk management issue if they want to do that. Okay. Anybody have anything else? Any questions, even non-property management related? Last time you guys had like 1,000 questions for me. So is there a special needs group that would like to rent a property? Do they fall under the same rules of no more than 4 unrelated persons? You're talking about situations, we've been hearing about this, that there are some nonprofits out in the out there who will try to find like a larger home in order to provide housing to adults with like disabilities, or even sometimes like recovering addicts or people with mental health issues and things like that. They are specifically exempt from that no more than 4 unrelated persons statute. They are treated as if they were family for those very, very limited circumstances. So usually it's some LLC is making the application, and they're going to turn around and they're going to basically provide occupancy to like 5, 6, 7. It can be up to 8. It can't be more than 8. Up to 8 people who would otherwise not be related, but they are there because they are, again, adults with disabilities. They get support in the property, or sometimes it can be like a halfway house for people with mental health or substance abuse issues and things like that. They are not subject to that restriction on no more than 4 unrelated persons. The number goes up to 8 in that scenario. But of course, a lot of times these LLCs, you could always ask for like a guarantor or something like that, because most of the time they don't have any private capital or anything in there, and they might not qualify from a credit standpoint. I'm seeing some thank yous coming in. Thank you to all who have joined. I will hang on for a few more minutes if anybody else has any questions, but again, I appreciate your attention and the opportunity.
Well, we appreciate you taking the time, and I know you and I are going to get together with a couple more topics that you have available for us to chat with. So appreciate it.
Absolutely. The way that all of this is changing right now, I'm getting new topics by the day. It's actually getting hard to keep up on some of them. So
I know. I'm sure you're doing a lot of research too. We had some folks that were interested in knowing a little bit in more detail about the CARES Act and how it relates specifically. I don't know if you can go through with regard to real estate.
Sure.
We've talked a little bit about forbearance. We're having a Monday mortgage meetup basically every Monday to go over and the we looked at the consumer protection video and some of that, but we're not quite sure. It's pretty intense, that thing. So
I have the misfortune of having read the entire 800 some odd page bill. There's quite a bit in there, and of course on top of that it's 800 pages, and then each the Department of Labor, Fannie Mae, Freddie Mac, Ginnie Mae, the Department of Homeland Security, Department of Health and Human Services, they all had to come out with guidance implementing it, and the Department of the Treasury and the Small Business Administration. So all of them had to come out with an additional 1,000 pages worth of regs in order to make the CARES Act relevant. So I'm going to hit kind of just the broad strokes on how it applies to our members specifically. Of course, I have to start out with, at least as of right now, all the money's already gone. I think most people who are following this realize that the first appropriation by Congress, even as a part of that $2.2 trillion CARES Act, was going to be insufficient to the issues going on right now. As of last Thursday morning, there are 2 main loan programs that are set up under the CARES Act that can be of benefit. One is the Payroll Protection Program, the PPP, and the other is the Economic Industry Injury Disaster Loan Program. Now, that's the EIDL. The EIDL has been around for years. It's been historically used in instances with like natural disasters to help small businesses get back on their feet after earthquakes, floods, tornadoes, hurricanes, that kind of thing. But they specifically expanded money for this for states that were had issued a state of emergency, which for the first time in American history, all 50 states are actually under a state of emergency right now. So if you are a small business and you have received, you have an economic injury, business has dried up where you can't operate, you suffered some kind of loss. Now, there are underwriting standards that a lender would be better to guide you through, but you actually can qualify for $10,000 grant up front, and then you can qualify for a loan. I think it's, some of them go up to 10 or 20 million, depending on the need. And if you follow certain kinds of criteria, the interest rate itself is very competitive. It's like 1%. But if you follow some criteria, some of the loan will be forgivable as well. So this is intended to try to keep businesses afloat. The Payroll Protection Program, the PPP, is a little bit more restrictive. It can be forgiven, which is a great benefit, but you have to spend at least 75% of the money that you get on keeping people employed, on protecting your payroll. So that means that you can still borrow the money and it won't be forgivable at competitive interest rates if you're not spending it on payroll. But if you want it to be forgivable, you have to spend most of it on payroll. Now, that might be attractive to some small business owners, particularly independent contractors who have LLCs that are set up and they just simply want to pay themselves kind of a salary, or maybe you've got an admin or a transaction coordinator or somebody on staff. So most of your expenses actually is payroll, and that might make sense. Again, the money's all dried up for these, but it seems like as of this morning, Congress is pretty close to a deal to expand another round of funding for that. Independent contractors and sole proprietors are eligible for these loans, and so certainly contact a lender. The PPP, part of the reason why that money dried up so quickly is it actually didn't go through the Small Business Administration. Any FDIC insured lending institution was actually able to issue the loans. Unfortunately, the Department of the Treasury gave them the underwriting guidelines about 12 hours before the application window went open. So really, most of the parties who have been able to take advantage of it so far are ones that have armies of lawyers and accountants on staff who can help them quickly pivot under these kinds of issues. So you did see that there were a lot of maybe what we would consider larger businesses, not small businesses, that were able to take advantage of it in the first round. But most of the lenders now have a better handle on it. If there's more funding on the way, hopefully we'll see more true small businesses being able to take advantage of it. I would certainly.
So with that, would it be a good idea then for us to put an application in prior to so get with somebody?
Yeah. I was actually going to suggest, and I would suggest going to a lending institution with which you already have a relationship. Not just walking into any place, because understandably there's a line around the block for this. I heard some statistics somewhere that the actual demand was somewhere closer in the ballpark of 3.5, or no, it was almost $3 trillion as opposed to 350 billion. So that so obviously people are lining up for that, but most lending institutions are prioritizing their existing clients for understandable reasons. Two that come to mind mostly is, number one, they already have a pre-existing relationship. You want to keep your client happy. And then number two, they've already done the know your customer requirements. Any financial institution that is going to open up a bank account or a line of credit with a person or a business has to actually go through and identify their sources of income. They have to verify their identities and things like that. That can take a few days. They're called KYC requirements. And it's a lot easier if you're trying to pump money out quickly to just go with the person you've already verified rather than go do your due diligence on somebody you don't have any relationship with. So that's so I would certainly encourage everybody, if you want a faster response time, is try to go to an institution with which you're already banking or you have a relationship. It'll make the process a lot faster. The last kind of stool under the that we like to highlight under the CARES Act is, for the first time in American history that I'm aware of, independent contractors are eligible for unemployment assistance. Now, as with everything else, the Department of Labor had to issue a bunch of guidelines. Because this has never happened before, we don't know how to determine eligibility or how much money you're entitled to as an independent contractor. It's a lot easier when you can send a few weeks worth of pay stubs to verify somebody's somebody's income, as opposed to people who, you know, get a few large checks a year sporadically. As of Monday, though, the Virginia Employment Commission was accepting, so as of yesterday, started accepting applications for independent contractors, gig workers, things like that. So if you don't have any business going on and you need, you know, you need unemployment assistance, check out the vec.virginia.gov website. The first tab at the top says applications now available for pandemic unemployment assistance. You're still not eligible for the state benefits because the state benefits have never historically covered independent contractors, but the federal benefit of $600 a week is eligible. It's just flowing through the state organization. So you fill out, provide them with the requested information, fill out the application, and you could be eligible up to potentially $600 a week in federal pandemic unemployment assistance, the PUA. The site again is V as in Virginia, E as in employment, C as in commission, vec.virginia.gov, G-O-V.
Is that Virginia spelled out or VA.gov?
It's Virginia spelled out.
Okay.
So it's a, you know, that's something that NAR advocated for very heavily on the federal level. They also have been advocating very heavily for the mortgage forbearance that is available to a lot of people. We do realize that it's that more needs to be done, and so we are advocating at every policy level to continue to address the situation. Because like we talked about with landlords earlier who may not be eligible for forbearance, but they have tenants who can't pay. And that $1,200 check that a lot of people got is probably going to run out pretty quick too. So,
Matt?
Yes, Cece.
Cece Webster, I had a frozen computer the whole time. I didn't want to touch it, so I couldn't ask question. Now I rebooted. I would have one question. Recent time, I believe within the few years back, that occupancy limit of 4 or you cannot 4 or more for single dwelling for unrelated, but they have also the occupancy limit on the size of room. If I understand correctly, each person, if you have to share the room, each person must have 50 square foot, which means 10 by 10 bedroom size you can share. Other than that, you cannot share by 2 people. That's my understanding. I clearly read that. Am I correct?
That's a general good rule of thumb. Typically speaking, the good rule of thumb is 2 per bedroom. But if you're going to add more, then the bedrooms have to be of a particular size. I believe in most jurisdictions, if you're going to do 3 to a bedroom, it's got to be like around, like you said, closer to 1,000 feet, I believe. The actual best resource for that on a case-by-case basis is to request information from the office. The zoning office maintains certificates of occupancy on every residential unit. They might also call it a RUP, a residential use permit, and that'll define how many people are legally allowed to inhabit that space. Now, this would not include children under the age of 1. Infants are not treated as a separate person.
Yes. Yeah, I did follow up with the renter properties occupancy limits. So that was the most, I thought, the area jurisdictions, you must have 50 square feet for each person in order to share. Well, infant, well, you can use the mom and pop room and crib. So, but I thought I wanted to completely understand that because I have told my landlords, if I represent them few, you have 8 by 10, that is not quite specification. My understanding is a 50 square feet. So I did read an article about that. I think it was a VAR. I don't know where it was, but I definitely believe it was there. So that's why I wanted to ask, since we have 11 people still on our Zoom call. So
The problem is that sometimes properties get grandfathered in, and that's why I can't give you a 100% answer, because there are properties that were built way back in the day. I mean, my mother growing up, she had siblings, and they had
Oh, yes.
and she had both of her parents. They had a 3-bedroom house. So, so sometimes things have been grandfathered in. The general rule of thumb is no more than 2 to a bedroom. If a bedroom is of a certain size, you can admit more. But yes, the good rule of thumb um, is 50 square feet above and beyond the if you're trying to add any more than just the 2 people.
Okay, but thank you.
Yeah.
You
And
always,
we don't get into, like, whether or not it's, sons and daughters sharing rooms
oh,
and
no,
things
no,
like
no,
that.
no,
That's
no,
that's up to the parents.
no. Yes. Well, thank you very much. Very big help.
My pleasure. Thank you. Would the room size be exempt for special needs students or religious organizations? Or you suggest we still need to call zoning? Generally speaking, there is no exemption for special needs students or religious organizations unless it's already built into the code. Now, there are certain kinds, like sometimes dorms might get if they're an older dorm, they might get some kind of variance or approval. The best resource is always zoning, just because they have those records. But if the property's been built sometime in the last 40 years, generally speaking, the best rule of thumb is going to be about two to a bedroom.
Now, another thing is that the protective category, students are not protective category because of you must have a grantor to sign up for it. A lot of people don't want to have a grantor living outside of a jurisdiction where the property is located, because in case the grantor didn't pay, and they can go after.
You have a hard time getting them into court.
Right.
Nope. Unfortunately, I used to do litigation, and I have had to pursue people out of state. Authenticating what is called a foreign judgment, when you have to go to another state to enforce a Virginia judgment, is never fun. But my only suggestion is that in that instance, you've got to be consistent. That if you are going to have guarantors, they've got to have some kind of collateral in the state. Otherwise, you're not going to be able to. It causes an enforcement issue. So that is certainly an objective basis upon which to say that you might reject an application, to say it's an out-of-state guarantor. We need an in-state one because we need one that we can easily reach if you all default. But you've got to apply it consistently, regardless of how many students, their race, religion, color, sex, national origin, all of that.
So another thing I want to protect myself is that my landlord doesn't want to have a student, say, don't want to have a 3-4 student. And then,
Not buying property near George Mason.
however, then if he doesn't want it, I cannot force him to do it.
You can't force him to do it, although if he's doing something now, I mean, just saying no students, generally speaking,
Yes,
isn't going
that's right.
to be necessarily discriminatory, because, like you said, being a student in and of itself is not a protected class. And as far as age goes, age only applies to elderliness, not youth.
Right.
So students are generally not a protected class, but you do have to be consistent, because now we're talking about essentially it's familial status. Are we discriminating against these people because they're not related to one another? And that's where the fair housing issue comes into play when you're dealing with students. So the best thing is to always fall back on objective standards, like you're talking about. They don't have credit. They don't have income. The guarantor is out of state, if they even have one. So approach each application as it is, and treat it under objective factors rather than just simply saying no students. Because when you start announcing things like that, it just draws unwanted attention to everybody involved and subjects you to an investigation. Even if you end up winning, nobody wants to be in the middle of in a fair housing investigation. They go on forever. They usually end up getting mediated, and it's just not a fun position to be in, even if you haven't done anything wrong.
There's a students call me when I have a property on the market, and they tell me 4 or 5 students, we all have job, so we pay good. But when you ask landlord to what to do about it, they say, no, I don't want a student to come in. So in that case, can I just say my landlord is not particularly accommodating student because of they might not have good credit or income. Therefore, I don't have to show it.
No, I think that be a potential fair housing issue in that scenario. You know, you can, if you have the same qualifications, if they were students or not, if you simply said, hey, look, I only show properties to people who are serious. So, you know, provide me with some kind of information to know that you're going to be able to afford this property,
Yes,
or I show it to you. If you do that to everybody, regardless of whether they're students or not,
exactly. Yes.
then that's not discriminatory. But if you're saying, oh, this is a group of students, I'm going to put in additional hurdles that they have to jump through, it's better to show them the property and then have them go through the application process and then apply the same standards you would apply to anybody else.
Okay.
You know, if you've got a landlord who would take, you know, a bunch of people in their late 20s or 30s under one credit standard, and you hire, or you have higher standards for students, that's a potential issue too. If the landlord's really that concerned, they should just have high standards and apply it to everybody.
Okay. Thank you.
Thank you.
Yeah, I've seen recently that in the remarks, it says no more than 2 incomes to qualify, which you just said is not kosher.
I mean, look, realistically speaking, you and we all know that it's going through the landlord's minds when they're taking a look at it. We do. But when you advertise it, it just draws unwanted attention to yourself.
Mm.
Any other questions? Anything I could do to help anybody else today?
Oh, great information. Thank you so much for your time.
All we need today. Thank you.
Thank you, everybody. I hope that everybody is doing well. Take care, stay safe. We look forward to seeing you all in the office hopefully soon. But in the meantime, continue that social distancing, help your clients however you can, take care of yourselves and your families, and we will get through this.
Yeah, thank you.
Thank you.
Stay safe.
Thanks, everybody. Take care.
All right.
Bye-bye.
Bye-bye.